Hello, all the CA Inter students. Hope you have done your accounts examination very well. Forget about the past. Don't even care about any video relating to accountancy, how to solve these answers. Nonsense. Keep that away. So let's concentrate on the paper number 2, corporate and other laws. With regard to the corporate and other laws, listen to this entire video what I am going to tell. Definitely it will give you 8 to 10 marks in the coming examination. You are having 2.5 days of golden time to crack the law examination with ease like a boss. So in this regard, I just wanted to tell you that I am now going to revise just in 45 minutes the complete 4 important segments which students generally leave, and this will be going to become the India's best revision on these 4 aspects. Number 1, penalties. Number 2, applicability criteria. Number 3, forms and formats. And number 4, resolutions to be passed. Let's go into the video without any delay. Complete this particular lecture and revise as many number of times as possible before exam. Success will be yours 100%. MCQs minimum 4 marks will come. Let's start. This is a penalty chart. Fastly I will be going into the concepts and complete. Listen carefully. Point number 1. If in case of 1% company, any fraud happens or any wrong happens, any mistake happens, okay, any contravention happens on the provisions, extend to 10,000 fine. Extend means maximum 10,000. And along with that, any extra day of default, 1,000 per day. See, you have to file financial statements. You did not file. 10,000 rupee penalty will be there. Fine. Up to 10,000. It can be 1 rupee also, up to 10,000. Along with that, for every single day, 1,000 rupee extra fine will be there. Unnecessarily, you are not using private limited or you are using private limited, means you should not use private limited. You should not use public limited or limited. You used. In that case, fine will be minimum 500, maximum up to 2,000 per day in which you are illegally using the name. Next, section number 4, reservation of a name. For reservation, we need to apply to ROC. If you furnish wrong information and apply, 2 situations, company not yet incorporated, company incorporated. Okay, company not incorporated, reservation style, they caught that you are a culprit. In that case, penalty up to 1 lakh. No sir, company incorporated. Then 3 options will be there for the government. Number 1, ask you to change the name, or take an action for strike off, or it will go for winding up. Understood the 3 actions? So what are the 3? Number 1, they ask you to change the name. Number 2, strike off the name. Number 3, directly winding up. Next one. Number 7, if any person furnishes any false information at the time of incorporation, okay, incorporation, you have to furnish that you are not criminally offended. You are not convicted of any crime in promotion, management or incorporation of company. At that time, if you give any false information, false Aadhaar cards, false identity proofs, etc., then you will be liable for 447. Next one. Company and officer in default, section number 8. Section 8 company, when it does not follow the provisions of section 8 properly, where license is cancelled because of doing so, then fine will be minimum 10 lakhs and a maximum 1 crore. And along with that, every director and officer in default shall be punishable with a fine of 25,000 and maximum up to 25 lakhs. 25,000 up to 25 lakhs. Then question will arise. What is this? This is for the company. This is for the directors and officers in default. Company, only fine. Company can't be imprisoned. Minimum 10 lakhs, maximum 1 crore. Directors and officers, fine will be 25,000 minimum, 25 lakhs maximum. Section number 12. Registered office of a company. If the registered office of a company, verification is not done within time, which is not done, verification is not done, or every registered office outside you should place the name of that company, everything. When it is a common seal, you should write the name of company on every letters, brochures or bills, letter papers, etc. You need to publish the name of that company. Any contravention of section 12 will lead to this particular penalty. Company and officer will be liable to a penalty of 1,000 for every day and but not exceeding 1 lakh. Next, section number 14, alteration of articles. See, remember one thing, alteration of articles and section number 12, both sides, this is 1,000 for every day, maximum up to 1 lakh. This is 1,000 for every copy. Means whenever you are altering your articles, altering after post the alteration, If anyone asks any alteration, you should give altered one, not the old one. If you give any altered one without such alteration, then for each copy you given to a person that way, 1000 rupees will be the penalty. Next. Section number 15. See, if a person asks you for copies of the memorandum and articles, you must give. If you don't give, company and officer in default shall be liable to a penalty of 1000 for each copy of memorandum and articles issued without alteration. Same. Memorandum also you should issue only with alteration. Without alteration, if you issue, here also 1000. So 14, 15 common. What is that? 1000 rupee for each copy. Next, 16. Rectification of name. Which one? Rectification of name. If you do not rectify the name even after the reasonable notice, then company will be liable to a penalty 1000 per day, and every officer will be liable for a penalty of 5000, maximum to 1 lakh. Main penalties only I will be discussing. Next, 26. Punishment. Prospectus should contain certain details. If prospectus do not contain those details, then the company and every party who is knowingly a party punishable with a fine minimum 50,000, maximum 3 lakhs. Generally in exam, incorporation law, section number 4 and section number 7 are important. Okay, only important ones let us discuss. Remaining you just to go through. Okay, prospectus law, all the 4 are very, very important. Fine 50,000, maximum 3 lakh. 39. Which one? 39. What do you mean by 39? In case company fails to return the amount to the subscribers, whenever minimum subscription is not received, you have to refund, or else you have to pay interest. Along with interest, okay, or in filing return of allotment with ROC, whenever allotment is not done, you have to refund. In that you made contravention. Or second one, you did not file return of allotment if allotment is successful. In both the cases, penalty 1000 for every day or 1 lakh, whichever is less. So 1000 per day or total 1 lakh, whichever is less. The next one, section number 40, any subscription related offenses are there. Penalty on the company will be fine, minimum 55 lakh and maximum will be 50 lakh. Officer in default, minimum 50,000, maximum will be 3 lakh. There are some small printing mistakes are there, that's why I have clearly written. Company minimum 5 lakh, maximum 50 lakh. Okay, officer in default, minimum 50,000, maximum 3 lakh. 42. Private placement offenses. If any private placement makes an offer or accept money in contravention of the section, then company, promoter, directors, all the 3 are liable. Amount involved in the offer is amount. How much is the penalty? Amount involved in the offer. If it is 100 crore, 100 crore or 2 crore, whichever is lower. If it is for 1 crore, 1 crore, 2 crore, whichever is lower means 1 crore. And the company shall refund all the money within 30 days. So, private placement itself is made to small group. You should not bring big penalty. Penalty should be there in order to avoid offenses. But it should not make the company insolvent. So, penalty will be amount involved in offer or 2 crore, whichever is lower. 50 lakhs or 2 crore, whichever is lower means 50 lakhs. Amount involved in offer, if it is 50 lakh, how can you levy a penalty of 1 crore? With what logic? So, therefore, maximum up to 2 crore is the thing. So, if it is minimum, take the lesser one. And the company shall refund within 30 days. Next, in share capital chapter, are there any important penalties? Is a question now. Okay. So, important penalties are section number 56 is one, section number 57 is one important. Personation means if any person pretends to be another person on documents, fake Aadhaar card like that, if they provide to company and get the shares allotted in their name, that impersonation offense if they do, then they will be liable for jail. Okay, 1 year, 3 years. So minimum 1 year, maximum 3 years. Minimum 1 year, maximum 3 years. And there will be a minimum fine of 1 lakh, maximum fine of 5 lakhs. You can read this way, it's easy word. Okay, so minimum 1 year jail, maximum 3 years imprisonment, and along with that minimum 1 lakh and maximum will be 5 lakh fine. Next one, any person. Next one, section number 58. Section number 58, it is regarding rectification in the registers and filing an appeal to the tribunal. If a person contravenes the orders of tribunal, that's what I said, we will go to tribunal that our name is not reflected in the register. Tribunal order say you are not following properly, then 1 year to 3 years, fine 1 lakh to 5 lakh. Important penalties I am telling, remember those without fail. Very, very important, section 67 and 68. Buyback related penalties. Company, minimum 1 lakh, maximum 25 lakh. Officer in default, minimum 1 lakh, maximum 25 lakh, and jail will be there, maximum 3 years. Remember 67 penalty. Buyback related, company is restricted to give loans to buy the shares of its company. That kind of offense 67. Buyback loan offense 68. Buyback offense 68. Okay, it is fine. Yeah, by mistake it might be printed as a fine. So minimum will be 1 lakh, maximum will be 25 lakh. Jail 3 years maximum. Fine will be minimum 1 lakh, maximum will be 25 lakh. Next, section 68. This will be buyback related. Company minimum 1 lakh, maximum 3 lakh. Officer in default also same. Next. Deposits acceptance. Which one? Deposits acceptance. In this 60, 74 and 76A, there are two sections which levy penalty and are very, very important. Both are important. Acceptance of deposits. If company fails to repay within the prescribed time, means accepted deposits but it failed to pay within the time, then the deposit or part of deposit or interest or penalty shall be as under. Okay, shall be as under. For the company, minimum 1 crore, then penalty shall be as under. Minimum 1 crore, maximum 10 crore. Next, officer in default, minimum 25 lakhs, maximum 2 crore, and jail up to 7 years. Jail up to 7 years. Okay, sometimes court may tell 7 years jail and this fine. Sometimes they will tell 7 years jail or this fine. Any of them they can levy. It depends on the court mood at that time. Okay, so therefore 74 section is very important for the examination for the penalty part. If a company fails to repay within prescribed time any deposit or part of deposit or interest, then the penalty will be as under. Company 1 crore to 10 crore. Officer in default 25 lakh to 2 crore. Along with that, sometimes jail for 7 years. Whenever jail is there, now it's a simplified term for the word imprisonment. Next. 73, 76. Acceptance of deposits made in contravention. Means what? We have to take the credit report, credit rating. We did not take, punishment. Director's permission we need to take. We did not, punishment. Circular we need to issue in DPT3. We did not, punishment. So, company, in addition to the payment of amount of deposit, that means you have to pay the deposit, you have to pay the interest. Along with that, fine minimum 1 crore or twice the amount of deposit accepted, whichever is lower. Okay, but which may extend up to 10 crore. So, how to understand this? Rupees 1 crore or twice the amount, whichever is lower. This will be the minimum. Maximum up to rupees 10 crore. Remember this, very, very important. Minimum will be, minimum has a two limits, whichever is lower. 1 crore or 2 times the amount, whichever is lower. Or maximum go up to 10 crore. Done. Every officer of the company who is in default shall be punishable with imprisonment 7 years plus fine 25 lakhs to 2 crore. Same as above. So 74, 76, you have to remember this way. 86, all these are not important. Next. Yeah. 88. Register of members you have to maintain. If you don't maintain, company 3 lakh, officer in default 50,000. Okay. There will be liable to a penalty. Company 3 lakh, officer in default 50,000. Okay. Next. Beneficial ownership. Whoever are the beneficial owner, for them also separate report we need to file. If you do not file, then for first time failure, fine not exceeding 50,000. Continuing failure, 200 for every day, which can reach up to 5 lakh. Next one, important ones are 92 is important. 92. Non-filing of annual return. Here the company fails even within 270 days from the expiry of 60-day time limit. That means simply, normally you have to file the annual return within 60 days of AGM. you did not file, another 270 days time is given, totally 330 days. Even then you did not file, then company and its officer in default will be liable to a penalty of rupees 10,000. After that, 10,000 is for non-filing. For every extra day, 1,000 rupees for each day, subject to a maximum of 2 lakhs. Subject to a maximum of 2 lakh. So that 2 lakhs is in case of company. If it is officer in default, that will be rupees 50,000. So how to understand? If company do not file the annual return even within the extended time of 270 with the 60 days already given, then with 330, then company and officer in default shall be liable to a penalty of 10,000 rupees. Company 10,000, officers in default, each one 10,000. Along with that, for any continuing default, 1,000 for each day. Maximum like that, how much? 2 lakh in case of company and 50,000 in case of officers. Same. If company secretary certifies an annual return which is not according to the provisions of Companies Act, then he will also be liable to a penalty of 2 lakh. Next. Minutes is again another important. Minutes related penalty. Penalty for company 25,000, office and default 5,000. If you tamper the minutes, that's a big crime. Na? So 25,000 fine, maximum 1 lakh. That's okay. Along with that, and very important, whenever and is there important, imprisonment up to 2 years. Next. 119. Inspection is not allowed for minutes. In that case, if it is refused or not furnished, then company 25,000, office and default 5,000 for each refusal or default. Next. These are all not that important here. Again, accounts of company penalties are very important. Very important for exam. Whenever books of accounts are not prepared, see, duty of maintenance of books of accounts will be with the managing director, whole-time director, manager. But if they feel so, they can transfer duty to CF or any other qualified person. In case of contravention, then that person, either CFO or the managing director, whole-time director, manager, etc., these people will be liable for fine 50,000, maximum to 5 lakh. Remember this, important. Financial statements preparation, if you have done the default, same like that. Okay, either managing director, whole-time director, or CFO or any eligible person appointed by board, jail up to 1 year and imprisonment up to 1 year, or fine minimum 50,000, maximum 5 lakh, or both. So fine is same. Here what you need to remember, 128, 129 lakh extra is imprisonment will be added, but it is or, not and. Next. 132. If any CA firm is having a professional misconduct, any chartered accountant is showing professional misconduct, then NFRA will levy a penalty of 1 lakh or 5 times the audit fees. Penalty of 5 lakh or 10 times the audit fees in case of firm. Individual na 1 lakh or 5 times. Firm na 5 lakh or 10 times. Super offer. In addition to that, it can debar the chartered accountant or the firm for 6 months to 10 years. So this is another important penalty you need to remember. If NFRA finds that any chartered accountant or a firm is doing any misconduct, it is proven, then penalty 1 lakh or 5 times the audit fees collected. Next, penalty 5 lakh or 10 times the audit fees collected in case of firm, along with the debar minimum 6 months, maximum 10 years. Board report, like if there is a contravention, board report, company 3 lakh and officer of the company 50,000. CSR, if a company is committing a default in subsection 5 and to spend the 2% or subsection 6 reporting, etc., shall be liable to penalty of twice the amount required to be transferred to the fund. If you do not spend in a CSR in any year, no problem, transfer to fund. If you do not transfer, twice the amount or 1 crore, whichever is less, liable to a penalty. Twice the CSR amount or 1 crore, whichever is less. That's the main point you need to remember. 136, circulation, not that important. 137, if financial statements are not filed properly, company 10,000, for continuing failure rupees 100 for each day, maximum 2 lakh. Annual return, if you see 92 section, 10,000 and 1,000, correct? Flat penalty 10,000 and 1,000. Here how much it is? 10,000. Instead of 1,000, it will be rupees 100 for each day till it reaches 2 lakh. Along with that, for not filing, Officers, the CFO, directors, etc. will be liable for 10,000 and 100 continuing failure, maximum up to 2 lakh. Same. This and this is same. Instead of 2 lakh, replace it with 50,000 if it is officers in default. Okay. Next, 140. ADT 3 is not filed. ADT 3 is not filed after appointment. Then 50,000 rupee. Auditor will be liable for a penalty of 50,000 or amount equal to remuneration, whichever is less. Okay. So 50,000 or auditor's remuneration, whichever is less. And if you continue that failure like that with pride, 5,500 for each day till it reach 2 lakh. Okay. Next one. Duties and powers. If you do not discharge your duties and powers, listed company 5 lakh, any other company 1 lakh. Cost audit, just read and leave, not that important. And 147 and 148. But 148, please read properly. This is not a time to spend time on this. Just you have to remember. Okay, just read after this. Now, penalties are completed. So I marked all the important penalties. They are almost around 15 will come. That 15 you revise properly. Next one. Resolutions chart. Okay. See, ordinary resolution when it is required. Ordinary resolution. Register direct to change company name. That is ordinary resolution. Central government want to change the name of the company within 3 or 6 months under section number 16. Then also ordinary resolution. Okay. See, reservation time lo ROC wanted you to change. Okay. Reservation time lo you have given wrong information. ROC said change the name. We said reservation time if any wrong information is given, 3 chances are there. Change the name, strike off, winding up. Or change the name to ordinary resolution. Central, you incorporated company. Mistake is with the government. What mistake government has done? Government has not seen that they incorporated company with a similar name or a trademark. Later they came to know that's not my mistake. Therefore, ordinary resolution. Any alteration of capital clause, ordinary resolution. Ordinary resolution means increase of capital, consolidation of capital, etc. Next one. Bonus shares issue, ordinary resolution. Okay, this anyway not there in the syllabus, just given for understanding. Deposits accepted from public, ordinary resolution. But if it exceeds the ceiling limit, what ceiling limit? If the deposits already accepted first, deposits proposed to be accepted exceeds aggregate of paid up share capital plus free reserves plus securities premium. Either we call 181C. In that case, special resolution or else ordinary. All ordinary businesses require ordinary resolution. Remuneration will be fixed by ordinary resolution. These are all special resolutions in your syllabus. Alteration of articles, shifting of registered office, alteration of memorandum, alteration of articles of association. Sir, 5 also same. 5 also alteration of articles say, but for conversion, public to private. This is general alteration. 1327, objects clause. Objects clause by a non-listed, unlisted company 13, listed company 27. Again, sweat equity share, special resolution. Rights offer, special resolution. Reduction, special resolution. Buyback, special. Debentures, convertible, special. And removal of auditor also requires special resolution. Next. These all not required for you. Board resolution is only for understanding. Postal ballot, very important. Alteration of articles of association in order to add private limited or in order to remove private limited and conversion time. Okay, next one. So next, 4 and 13, alteration of objects clause of memorandum. Okay, alteration of objects clause of memorandum, either main objects also. Okay, normal object or main object. At that time, alteration of memorandum, objects clause change, require postal ballot, not all. Next, change in register office within the local limits of a town, city or village, then also required. Next, objects clause by a listed company, then also required. General object required, listed company also required. Issue of shares for differential rights required. Variation in shareholders' rights, section 48 required. Buyback also required. Postal ballot and a general meeting not required. Instead of general meeting, postal ballot. Next. Registers not that important, just give a reading and leave. Central government approval. Section 8. License key we need to apply to CG. Section number 12. Whenever you wanted to change the register office from one state to another, central government permission is required. NFRA, central government. Okay, CSR, CG may give special or general directions to you in that case. Next, removal of auditor key we require central government approval. Okay, some companies like government companies, rotation also central government approval is required. Next, some forms. Important, see here. One person company is there, na? Which one? One person company. INC 3 la they have to file. Okay, consent form. Consent. Whose consent? Nominee's consent should be filed in INC 3. Okay, I wanted to change names. INC 4 in case of one person company. Okay, I wanted to apply for conversion of OPC into other company. INC 6. I wanted to incorporate companies. FICE form. INC 32. Next, advertisement of prospectus. Prospectus can be advertised in a format given by the government, not in your advertisement form, like a cinema advertisement. Further, there is a format PAS 1. Information memorandum PAS 2. Return of allotment filed with ROC PAS 3. Private placement offer letter in PAS 4. Okay, this is not required. Next, share certificate given in SH 1. Duplicate certificate in SH 2. Alteration of share capital whenever happened SH 7. I am writing only what are applicable for your exam. Section number, so rule number also I have written there. Okay. Next, buyback key, we have to give a letter of offer to the members na SH 8. And buyback time we have to give declaration of solvency SH 9. Buyback after completion, we have to file a return of buyback SH 11. SH 11. Acceptance of deposits by company. Circular should be issued to members in DPT 1. Deposit trust deed. If deposit trustee is appointed, it will be filed in DPT 2 with ROC. Return of deposit once accepted, DPT 3. For this only we saw the penalty there, not filing. Very, very important is the charges chapter. CHG 1. CHG 1. If you are applying for registration or modification or creation, CHG 1. Whenever you paid the charges over, means you paid the loan, satisfaction of charge, CHG 4. Okay. Next, if your company is insolvent, official assignee or manager will be appointed. At that time, details of that person will be filed in CHG 6. We will apply to the CG for extension of time limits for filing the charge registers or for rectification. Extension of time for registration or for rectification of any mistakes in the document already filed. CHG 8. Next, management administration. MGT 7, annual return. 7A, abridged annual return in case of OPC and small company. Important here. MGT 14, whenever special resolution or some agreements are filed, you have to file MGT 14 within 30 days. Annual general meeting report shall be filed in MGT 15. Beneficial owners will be filed in BEN 2 form. Accounts of company, financial statements AOC 4, certain companies XBRL filing AOC 4 is XBRL. Next, CSR activities undertaken in CSR 1, report on CSR in CSR 2. Very, very important. Another chapter will be auditors. Definitely one question will come from this. Remember carefully. Auditor is appointed. ADT 1. You removed him. ADT 2. Appointment 1. Removal 2. Resignation 3. Appointment 1. Removal 2. Resignation 3. Fraud 4. Next, cost auditor appointment. Okay. Then appointment, intimation of appointment of cost auditor, CRA 2. Cost audit report will be filed in CRA 4. Next, limits chart. What chart here? Limits chart. These limits are continuously tested in examination in various forms. Okay. What are the limits? Associate company to become significant influence means more than or equal to 20% of total voting power under an agreement. Means you should have at least 20% of the total voting power. At least. Minimum. Means more than or equal to 20%. Clear? Next, government company. 51% is the limit for government company. Small company. Paid up share capital not more than 4 crore and turnover not more than 40 crore. Subsidiary company, 1/2 of total voting power. More than 1/2. Okay. Next, underwriting commission. Brokerage. Shares ki 5% of issue price, debentures ki 2.5% or whatever the amount mentioned in articles, whichever is lower. Private placement, number of persons to whom you can issue can't exceed 200 in aggregate in one financial year. Next, 48, variation. Consent can be obtained in two ways. Either individual consent if you wanted to apply not less than 3/4 of the issued shares. Okay, whoever is holding not less than 3/4 of the issued share, their permission. Or if that is difficult to take each and every person's permission, then special resolution. Okay, appeal can be made by shareholders holding not less than, means more than or equal to 10% of issued shares. Next, redemption of preference shares. Generally, not less than or equal to 20 years. But if it is infrastructure company, 30 years also they can issue, but part redemption should happen after 21 year onwards. Next, duplicate share certificate, just a month you remember. Next, very, very important here. Whenever company is giving loan to the employees to purchase its own shares, then the loan given should not exceed his 6 month salary. Buyback, very, 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 very important. Buyback, see, special resolution is not required for buyback. When you should obtain board approval, and amount of buyback should not exceed, means less than or equal to 10% of paid up equity share capital plus free reserves. Maximum buyback in one financial year, 25% of paid up share capital, not equity, both preference and equity, plus free reserves. Total in lifetime, 25% of paid up equity share capital. Debt equity ratio should not be more than 2:1. Next, 76 deposit. DRR, at least 20% of the deposits maturing next year, you need to put in DRR. Okay. Next, less than 6 months deposit can be accepted. Yes, minimum 3 months. Okay, and it should be up to 10% of paid up share capital free reserves on securities premium account. Okay. Next, totally 35% chance they will give from public and members. 10% they can raise from members, 25% from the public. This you need to remember. Paid up share capital plus free reserves plus securities premium. Eligible government company, 35% they can take. Deposits can be accepted up to that particular extent. Okay. From members. Only from members, 35 and 100. Public deposits. Eligible public company. Net worth should be more than or equal to 100 crores or turnover should be more than or equal to 500 crores. Annual return. Who should file annual return? Okay. Which kind of company should get their annual return certified by CAS? Listed company or company having a paid up share capital of more than 10 crore, more than equal to 10 crore, or turnover more than equal to 50 crore. This is another important question for your exams. EGM. All these, sir. General meetings chapter I need not, because so many number of times you already read. Just you can take a snap and you can read all these things, because in general meetings chapter anyway we will read all these. So nothing great to read in this particular area. Okay. These are all various limits that you need to remember. If anyone don't have, at least take a snap. Why I am not discussing these? Because these are all already important chapters. In that chapter you might have already read. There is no point of wasting time now. Next. These are all normal sections. Anyway, you have to read in accounts of company chapter all this. Okay. Last one. Okay. Done. So these are all the things you need to do. Okay. All the very best. Get good marks, which should be not less than 60 marks. Okay. All the very best. God bless you all. I will be seeing you in CA Final, AFM and Direct Access classes. Okay. All the very best. Thank you.